with Disabilities, how you can ensure compliance with IDEA and Section 504. My name is Elka Sachs, and with me here is Allison Belanger. We are both members of the charter school practice here at Krokidas and Bluestein. Krokidas and Bluestein has represented charter schools since the first charter schools formed in 1995. We are also honored to represent the Massachusetts Charter Public School Association, today's host. We have a full-service charter school practice, including governance, state ethics, contracting, public procurement, real estate acquisition and development, finance, employment and labor law, special education, student discipline, student records, and physical restraint. Our focus today will be the discipline of children with disabilities in compliance with law. Before Allison and I begin to discuss the discipline procedures, I'm going to share a couple of quick notes about the webinar process for those of you who aren't familiar. While we will be emailing a copy of this presentation to you in the coming days, the PowerPoint slides are ready for you to download right now if you'd like, available in the handout section on the GoToWebinar panel. If you have any questions at any point, you can type them into the questions box on your screen during the presentation. We will have plenty of time for questions and answers at the end of the presentation. Your questions will only be visible to me and to Allison. They are not visible to other webinar participants. Feel free to share your name and school when you ask your question, but if you prefer to remain anonymous, please let us know. Our goal today is to provide an overview of how the Massachusetts Student Discipline Regulations and Statutes intersect with IDEA and Section 504, including when and how Section 504 and IDEA apply, how school disciplinary procedures should proceed in both standard and emergency discipline situations, and the various ways in which parents might challenge school decisions. For purposes of this webinar, we have created a who, what, where, how, when, and why framework to guide our discussion. In particular, we're going to look at what the applicable legal framework is, who is protected by IDEA and Section 504, how a school may discipline a child when IDEA or Section 504 apply, when parents challenge disciplinary decisions and in what manner they choose to do so, and where missteps tend to happen. Finally, we will wrap up with a couple of suggestions about how you can prepare for student discipline situations in which the child is entitled to IDEA or Section 504 protections. Allison, why don't you get started by discussing the legal framework that applies to today's webinar and the children who are entitled to IDEA and Section 504 protections in disciplinary situations.
Thanks, Elka. As you can see, there are three primary sets of laws that could apply and occasionally apply concurrently in these types of situations. In no particular order, you can see that first, there is the Individuals with Disabilities Education Act, which is most often referred to as IDEA. IDEA provides that all children are entitled to a free, accessible public education, which is known as STATE, including children with disabilities, and further including those students that are or have been suspended or expelled from school. Second, you have to consider the Rehabilitation Act of 1973. The relevant section of that act is Section 504, which, like IDEA, provides that public schools must provide FAPE to each qualified handicapped person, regardless of the nature or severity of that individual's handicap. Section 504 also prohibits the school from discriminating against individuals with disabilities, denying those persons the benefits of its programs, or excluding those individuals from participation in its programs. Finally, state law also applies. These include those laws that govern a student's rights when he or she commits a Big Four offense, and the student discipline regulations, which set out the discipline procedure for non-Big Four offenses. These state laws establish a baseline layer of protection for all students, even those without disabilities. IDEA and Section 504 build on those protections, creating even more procedural complexity to disciplinary situations. That is, the procedural steps that a school must take will change depending on whether a student is entitled to the additional protections of IDEA, Section 504, or both. In some circumstances, there are even differences between IDEA and Section 504, which we'll discuss as they arise, meaning that these processes could be different depending on by which law the student is covered. Therefore, as Elka will explain later, the first step in a disciplinary situation is to determine whether the student is protected by IDEA, Section 504, or both. To do that, you have to know that IDEA in general applies to children with disabilities. A child with a disability is a child who has a disability and needs special education and related services because of his or her disability. IDEA defines the term disability by setting out a long list of specific disabilities, including, for example, specific learning disabilities. Section 504 is often considered broader than IDEA and protects qualified handicapped persons from discrimination, meaning those persons who have physical or mental impairments that substantially limit one or more major life activities, such as learning. However, when it comes to disciplinary situations, the protections of Section 504 and IDEA expand even further. That is, in disciplinary situations, IDEA applies not only to students already identified as children with disabilities, but also to children about whom the school has knowledge fit within the definition of children with disabilities. A school is deemed to have knowledge that a child is a child with a disability if, prior to the behavior that prompted the disciplinary action at hand, one or more of three things happened. One, if a parent expressed concern to the school in writing that the child needs special education or related services. Two, if a parent requested an evaluation of the child. Or three, if school staff, a teacher or otherwise, expressed specific concerns about a child's behavior directly to the director of special education or other supervisory personnel of the school. If one of these things happens, not only are the school's child find obligations triggered, but the child becomes entitled to the additional protections of IDEA in disciplinary processes. Similarly, Section 504 broadens the scope of its applicability in disciplinary situations, albeit in a less explicit manner than IDEA. Section 504 provides that its disciplinary protections apply not only to qualified handicapped persons, but also to students who need or are believed to need special education or related services by reason of their handicap. Unlike IDEA, Section 504 does not set out specific actions that will put a school on notice that a student qualifies for its protections, meaning that schools should consider each situation on a case-by-case basis. Once you've determined that a student is entitled to the additional protections of either or both IDEA and Section 504, the question, of course, becomes exactly how you should proceed with the potential discipline without running afoul of IDEA and or Section 504. Elka, I'll turn it back to you to discuss this.
Thanks, Allison. We're going to cover three key topics: the change in placement trigger, the manifestation determination review, including timing, procedures, and outcomes, and special circumstances and emergencies. But first, a brief outline of the 4 steps that should generally be taken when a disciplinary situation erupts, if suspension will be considered. Later on in this presentation, we'll discuss a number of special circumstances and emergency situations that might allow a school to defer or forego a couple of these steps, but we will begin by discussing the more typical situations. In all situations, step 1 is to determine whether the child is entitled to IDEA or Section 504 protections. This step should be taken as soon as a school is aware that a child may be suspended or expelled if a Big 4 offense is being considered, and that a hearing will be scheduled. In all situations, step 2 is to conduct a hearing in accordance with Big 4 due process procedures or the Massachusetts student discipline regulations, whichever apply. Hearings are always required when a suspension is imposed, although in the case of an emergency, the Massachusetts student discipline regulations might permit removal prior to the hearing. In the general case, step 3, which we will discuss momentarily, is to determine whether the proposed discipline will result in a change in placement. Finally, if the proposed discipline will result in a change in placement, in the general case, step 4 is to conduct a manifestation determination review, which will determine whether discipline can be imposed and any other steps which must be taken. Under both IDEA and Section 504, a change in placement triggers protections for eligible students. Under both IDEA and Section 504, a removal for more than 10 consecutive days constitutes a change in placement. Similarly, both IDEA and Section 504 view removals for more than 10 non-consecutive days as a change in placement, if the removal is part of a pattern of removals. In determining whether there is a pattern, both Section 504 and IDEA look at the length of each removal and the proximity of removals to each other. There is a slight difference between the IDEA and Section 504 analyses in that IDEA asks whether the removals are for substantially similar behavior, while Section 504 does not. As a practical matter, we encourage our clients to be cautious and conservative and treat all removals of more than 10 days, including 10 non-consecutive days, to be a change in placement. However, case-by-case analysis can be warranted. If the discipline proposed to be implemented constitutes a change in placement, the next step is to conduct a manifestation determination review in most circumstances. There is a slight difference between the manifestation determination conducted for children entitled to IDEA protections and the manifestation determination conducted for children entitled to Section 504 protections. Under IDEA, the manifestation determination asks two questions. First, was the conduct caused by or did it have a substantial and direct relationship to the child's disability? Second, was the conduct a direct result of the failure to implement the child's IEP? Under Section 504, the manifestation determination focuses on a variation of the first question asked under IDEA. Was the conduct caused by the child's handicapping condition? And for those who prefer visual presentations, we've created a graphic displaying the difference between the questions posed in a manifestation determination review under IDEA and the one question posed under Section 504. Although the wording of IDEA and Section 504 are somewhat different, the general rule is that the manifestation determination review must occur before a change in placement can be implemented. For this reason, we strongly recommend that efforts be taken to schedule the manifestation determination as soon as possible following the disciplinary hearing, if there is any reason to believe that the hearing will result in a change in placement. As you know, the procedure you follow for the disciplinary hearing differs depending on the length of the removal you contemplate, in other words, whether it's a short-term or long-term suspension, under the Massachusetts Student Discipline Regulations. Therefore, even before scheduling the hearing, you should be able to determine whether the contemplated removal, if implemented, will constitute a change in placement. This allows you to determine, even in advance of the disciplinary hearing, whether a manifestation determination would be necessary, which further allows you to schedule the manifestation determination review immediately after the hearing, conditioning its occurrence on the results of the hearing. Under IDEA, the manifestation determination review team includes the school, the parents, and the relevant members of the student's IEP team. It's very important to engage parents by any means possible, and the school should document those efforts. Under Section 504, the manifestation determination review should be made by persons knowledgeable about the student and the meaning of the information that will be discussed. The key under Section 504 is that the team cannot include persons responsible for regular disciplinary procedures. In some charter schools, this might complicate the role of the dean of students or the person in a similar position who might serve as the quote-unquote principal for purposes of the initial hearing under the Massachusetts Student Discipline Regulations, but whose insight might also be helpful during the manifestation determination review. Under IDEA, the manifestation determination review asks two questions, so there are three possible outcomes. The first question is whether the conduct was caused by or had a substantial and direct relationship to the child's disability. If the answer is yes, outcome one, the school must conduct a functional behavioral assessment and implement or review and modify a behavioral implementation plan. The child cannot be disciplined and must be returned to his or her initial placement. The second question is whether the conduct resulted from the school's failure to implement the IEP. If the answer is yes, outcome 2, the school must take steps immediately to remedy the deficiencies. The child cannot be disciplined and must be returned to his or her placement in compliance with the IEP. If the answer to both questions is no, outcome 3, and the conduct was not a manifestation of the child's disability or the result of a failure to implement the child's IEP, the child may be disciplined like any other child. However, the school must determine appropriate services to enable the child to participate and make progress toward the IEP goals, which will likely require an IEP team meeting. In addition, a functional behavioral assessment should be conducted and a behavioral implementation plan created or modified to help avoid future misconduct. And for those who like graphic presentations, we've created a flow chart displaying the potential outcomes of an idea manifestation determination review. So turning to Section 504, under Section 504, the Manifestation Determination Review asks only one question, so we have only 2 potential outcomes. If the conduct was caused by the child's handicapping condition, the evaluation is continued to determine whether the current placement is appropriate and no discipline is imposed. In contrast, if the conduct is not a manifestation of the child's disability, the child can be disciplined the same as any other child. However, keep in mind that under the Massachusetts Student Discipline Regulations, the child must be provided with the opportunity to make academic progress, which includes providing the child with information about available special education services. And again, for those who prefer graphic presentations, we've created a flow chart displaying the potential outcomes of a Section 504 manifestation determination. At this point, I'm going to turn from the general situation to special circumstances and emergencies, which might allow a school to forego or defer a manifestation determination. Under IDEA, a school may unilaterally remove a child without conducting a manifestation determination review and place the child in an interim alternative educational setting for up to 45 school days if the child either carries or possesses a weapon, possesses, uses, sells, or solicits the sale of a controlled substance, or has inflicted serious bodily injury upon another person while at school, on school premises, or at a school function. Situations also arise where the school believes that a child poses a threat to the health or safety of himself or herself or to others. In these situations, a school may request an expedited due process hearing at the Bureau of Special Education Appeals, or the BSEA. The BSEA hearing officer may order an interim alternative educational placement for up to 45 days if the hearing officer determines that keeping the student at school is substantially likely to result in injury to himself or herself or to others. In all situations, the school may file an action in court for injunctive relief or report the emergency situation to a school resource officer or to the police. And here's a graphic presentation of the alternatives available in special circumstances and emergencies when a child is entitled to IDEA protections. Section 504 incorporates many fewer special circumstances than IDEA. Under Section 504, a student with a disability who is currently engaged in the illegal use of drugs or alcohol may be disciplined using the school's regular disciplinary procedures. However, this special exception does not apply when a school seeks to discipline a child entitled to Section 504 protections for possession of drugs or alcohol. Unlike IDEA, Section 504 does not provide a special exception when a student has inflicted bodily injury on another person or when a student poses a threat to the health or safety of himself or herself. However, under Section 504, if a child poses a direct threat to the health or safety of others, not to himself or herself, the school may impose discipline even if the manifestation determination results in a finding that the behavior was caused by the child's disability. As we discussed in connection with IDEA, in all emergency situations, the school may call emergency services or seek injunctive relief from the courts. And we wrap up our discussion of special circumstances and emergencies with another graphic presentation of the options available when the child's entitled to Section 504 protections. Allison's going to take over from here to discuss the various steps that parents can take to challenge a school's decision.
Thanks, Elka. So at many different points throughout the process that Elka just discussed, parents might challenge a school's decisions. For example, a parent may challenge a school's determination of whether or not his or her child is entitled to IDEA or Section 504 protection. In the disciplinary context, you may see this arise when you discipline a child who does not have an IEP or a Section 504 plan, and you do so without conducting a manifestation determination, and the parent nevertheless argues that you should have conducted a manifestation determination because you were on notice that the student has disability and was protected by federal law. You may also see these challenges to manifestation determination outcomes. Often, when it is determined that a child's behavior was not a manifestation of his or her disability and you impose discipline, the parent will disagree and argue that the behavior was, in fact, a manifestation of the child's disability and you should have been precluded from imposing the discipline. Finally, as you would see in non-special education contexts, you might also come across challenges to your disciplinary decisions in general, whether the facts warranted the imposition of any discipline, regardless of disability. These challenges might also involve challenges to the length or severity of the discipline imposed. There are many different routes that a parent can take to make these challenges. Those routes that are available to parents will depend on whether the student is entitled to the protections of Section 504, IDEA, or both, and on the basis of the parent's challenge. I will discuss each option in turn. First, IDEA requires that schools implement mediation procedures to address IDEA-related challenges. Schools are welcome to open these mediation procedures to Section 504-related challenges, but are not required to do so. Mediation is also available through the Office of Civil Rights of the United States Department of Education, as well as through the Massachusetts Bureau of Special Education Appeals. Second, parents may also choose to challenge disciplinary decisions using the appeals procedures set forth in the student discipline regulations. That is, through the Massachusetts Student Discipline Regulations, regardless of coverage by IDEA or Section 504, a student has a right to appeal a long-term suspension to a quote-unquote superintendent. Recall that charter schools are required to designate an individual to serve as the superintendent for the purposes of effectuating the student discipline regulations. In order to take advantage of this appeal right, an individual seeking to challenge a removal must provide written notice of the appeal within 5 days of the effective date of the suspension. Because the other routes, which I will discuss, have longer statutes of limitations, parents may choose not to take advantage of this appeal right in particular. Third, parents may also submit a complaint to the charter school's Board of Trustees, which, upon receiving such a complaint, must respond within 45 days. Note that this is a little different than appealing a decision. The parent here is not requesting that a decision be overturned or changed. Rather, the parent is entitled to complain to the Board of Trustees that the school violated a certain law, such as IDEA or Section 504. The Board of Trustees must then conduct an investigation to determine if the school did in fact commit such a violation. While there is no obligation for the board to transmit the results of its investigation to DESE, a complainant who is unsatisfied with the board's decision may directly submit a complaint to DESE, which could, in turn, result in the imposition of charter conditions or the suspension or revocation of a school's charter. And in conducting these investigations, the Board of Trustees has some discretion. However, if you do receive a complaint like this, you should look to your bylaws to see if they outline a stricter process for handling complaints or conducting investigations. Fourth, parents may choose to take advantage of a school's grievance procedures, which it is required by Section 504 to maintain. While Section 504 provides very little guidance as to what these grievance procedures must include, the Office of Civil Rights has explained that in determining whether the grievance procedures provide for the prompt and equitable resolution of complaints, it will examine factors such as the extent to which notice of the procedures have been provided to students, parents, and employees of the school, whether the procedures afford an opportunity for adequate, reliable, and impartial investigation, whether reasonably prompt timeframes have been established for the various stages of the complaint process, whether notice of the outcomes of the complaint have been provided to the parties, and whether there is an assurance that any violations will be addressed and that steps will be taken to prevent recurrence. Fifth, IDEA requires DESE to maintain a problem resolution system to receive complaints of both individual and systematic noncompliance. An individual wishing to submit a complaint to the system must do so within 1 year of the alleged violation occurring. While this is only required of IDEA, DESE welcomes individuals to submit complaints regarding any state or federal education law, including Section 504. DESE must issue a decision within 60 days of the filing of one of these complaints, unless exceptional circumstances exist that warrant a later decision, or unless the parties agree to extend that deadline in order to engage in mediation. DESE also might conduct on-site investigations related to complaints received by this system and then have broad flexibility to determine appropriate remedies. Sixth, a parent may request a due process hearing by the BSEA, the Bureau of Special Education Appeals. Note that the parent may do so in addition to submitting a complaint to the problem resolution system. If that is done, the problem resolution system process pauses while the BSEA process moves forward. Parents may choose this option over the problem resolution system option because they have 2 years following a violation to submit a complaint, as opposed to the 1-year statute of limitation to the problem resolution system. When a parent submits a complaint to the BSEA under the due process hearing rules, the school has a couple of responsibilities that call for quick turnaround. First, it must respond to the complaint within 10 calendar days of its receipt of the complaint. And second, it must call a meeting with the opposing party within 15 calendar days of its receipt of the complaint. This meeting is called a resolution session and is intended to give the parties an opportunity to negotiate an agreement rather than move forward with a hearing. In a further effort to encourage negotiated resolutions between parties, the BSEA will not conduct a hearing until after 30 days have passed from the filing of the complaint. That initial 30-day period is called the resolution period. Only after that resolution period expires, if the parties fail to reach an agreement within that period, will the BSEA proceed to conduct a hearing. Then, within 45 days of the expiration date of the resolution period, or 75 days after the receipt of the complaint, the BSEA must reach a final decision. This due process hearing option at the BSEA is also available on an expedited basis. The party submitting the complaint seeking placement on the expedited track must state a reason why it should be expedited. If expedited status is granted, all of the deadlines move up and a decision will be reached by the BSEA hearing officer within 30 days of the date the complaint is received. In either event, expedited or standard, the parties may request an extension of a time frame subject to the hearing officer's approval. Also, in either event, expedited or standard, the parties may waive the requirement to participate in a resolution session if they agree to mediate in lieu of the resolution session, or if they agree in writing to waive the requirement of the resolution session. If neither of those events occur, it is the school's responsibility to call the resolution meeting within the appropriate time frame, depending on whether it is on the standard or expedited track. And it's also the school's responsibility to obtain the cooperation of the parent for that resolution meeting. The school must make reasonable efforts to obtain parent participation, and it must document those efforts. If the parent nevertheless remains uncooperative, the school may request that the BSEA dismiss the complaint. Also, IEP or 504 team members who have knowledge of the facts of the situation and a school representative with decision-making authority must participate in this resolution session. Finally, you should note that an attorney for a school may not attend the resolution session unless the parent brings an attorney. If the parents do reach a resolution within the resolution period, the parties must put that resolution in writing. However, each party has the right to void the agreement within 3 days of signing it. If a party wishes to appeal a decision of the BSEA, it may do so to a state or federal court. There is no administrative appeals process for this. Finally, if at any point after a decision is reached, a party thinks that the other party is not implementing the decision that was made, the individual may file a motion with the BSEA contending that the decision is not being implemented. 7, if a parent is alleging a violation of Section 504, the parent may submit a complaint to the Office of Civil Rights of the U.S. Department of Education. If a parent chooses to do this, the parent must do so within 180 days of the last act of alleged discrimination, unless he or she can show good cause why the complaint was delayed. The Office of Civil Rights will first try to agree to voluntary compliance by the school through negotiation of a corrective action agreement. However, if the school does not voluntarily comply, OCR may terminate federal financial assistance to the school or refer the case to the Department of Justice for judicial proceedings. Keep in mind that a school may appeal any decision of OCR regarding its compliance with Section 504. 8, and lastly, parents have a private right of action against schools for violations of IDEA and Section 504. For any action, a court may order compensatory services or specific performance, which is ordering a school to take a specific action to remedy a violation. Additionally, if a parent successfully argues that a school violated IDEA in that the school denied a student FAPE and the parent had expended money to enroll his or her student in another school, the court could order tuition reimbursement. However, a claim alleging a violation of IDEA cannot otherwise result in monetary damages against a school. Conversely, a court may order monetary damages against a school for a violation of Section 504. And finally, there is a state law which permits monetary damages against schools that wrongfully exclude children. This applies to all students regardless of disability. If a parent is alleging a violation of FAPE, regardless of whether they're alleging the violation under IDEA or Section 504, the parent must first exhaust his or her administrative remedies, those that we just discussed, before bringing a private right of action. As you can see, there are several ways a parent may challenge a school's decision, each with different procedural rules and timelines. While complete avoidance of parental challenges might be unrealistic, you do want to avoid this complex web of remedies to the extent feasible. For that reason, I'll now turn it over to Elka, who will highlight a few places where we see common mistakes occur, which are easily avoidable. Elka?
Thanks, Allison, for walking us through the many ways in which parents can challenge a school's decision. I'm going to talk a bit about some of the issues we have seen in assisting schools with disciplining children entitled to IDEA and Section 504 protections. The first is a question of timing. Often we are called about a thorny discipline issue, the person calling us not having yet identified whether the child is entitled to Section 504 or IDEA protections. This means that the school has not yet thought through the logistics of scheduling a manifestation determination review, which is critical in these situations. A second issue that comes up repeatedly is the potential misuse of alternatives to discipline. DESE strongly encourages the use of alternatives to discipline. However, some of these, such as suspension from the school bus, can be inconsistent with a child's IEP or Section 504 plan. Others might fail as alternatives. For example, a visit to the principal's office of more than half a day will constitute a suspension, at least for Massachusetts student discipline regulations purposes. Even a shorter visit to the principal's office might violate IDEA or Section 504 if the child misses critical services. Last, we find that schools sometimes fail to provide necessary services during the suspension period. A child with an IEP is required to receive services during suspension that allow him or her to meet his or her IEP goals. And although Section 504 does not appear to contain an equivalent requirement, the Massachusetts Student Discipline Regulations do require students to have an opportunity to make academic progress toward meeting state and local requirements, which includes special education services as applicable. So how can schools prepare? Unfortunately, many school discipline issues concerning children with special needs emerge as crises. However, there are a few things that schools can do to prepare. The first is to ensure that schools have a good set of checklists and forms compliant with the Massachusetts Student Discipline Regulations. Although the student disciplinary process must halt to permit a manifestation determination in most circumstances in which a change of placement is proposed, it is helpful to have one less basis for a parental challenge. Second, schools should be sure that they have grievance procedures in place compliant with Section 504. Third, training of staff responsible for discipline and their supervisors is critical. And last but not least, it is important to have a clear chain of supervision among faculty and staff who might be involved in discipline, able to respond to questions and provide oversight. At this point, our formal presentation has ended, and we're going to open it up to questions and answers. We've received several questions during the webinar, but we also received a number of questions in advance, and we're going to begin with those. Thank you to all who submitted questions. Our first question is one that provides a great opportunity to run through everything that we just discussed on a step-by-step basis. For this reason, we've posted this particular question and provided an outline of our response. So Allison, you want to take it from here?
Sure. So we were asked what the required steps are around an emergency removal when a student has served more than 10 days of out-of-school suspension. This question presents a pretty complicated scenario because it highlights the intersection between the Massachusetts Student Discipline Regulations and IDEA in Section 504. But before we get into those nuances, keep in mind that in all emergencies, you may always contact the police or a school resource officer if the circumstances justify it. You may also always file an action in court for injunctive relief, by which a court could order an injunction against the student, prohibiting him or her from partaking in certain activities, such as entering school premises. When dealing with emergency situations, you should always take a step back and remember the general rules that we've discussed. First, the Massachusetts Student Discipline Regulations prohibit the removal of a student prior to conducting a disciplinary hearing. And second, both IDEA and Section 504 prohibit the removal of a student prior to conducting a manifestation determination if the removal constitutes a change in placement. As Elka just discussed, however, there are a couple of exceptions to these general rules which might permit you to remove the student prior to conducting the disciplinary hearing and or prior to completing the manifestation determination review. However, before we look to those exceptions, we consider those exceptions, to track the framework that we explained earlier, the very first step in all disciplinary situations is to determine if the student is entitled to the protections of Section 504 or IDEA. For the sake of keeping this question within the scope of this webinar, we will assume that the child is, in fact, entitled to such protections. Then, again to track the framework that we discussed earlier, the second step is to consider the type of removal you're contemplating. This is important because it allows you to plan the disciplinary hearing and the manifestation determination review. It is important that you start planning these events as soon as you can because you will not be able to remove the student prior to conducting them if you ultimately find that no exception applies. Then you have to determine whether an exception does apply. As Elka explained earlier, the third step in these situations is to conduct a disciplinary hearing. However, you might be able to remove the student prior to conducting this hearing if the emergency removal rule of the Massachusetts Student Discipline Regulations applies. The emergency removal rule applies if the principal determines that the continued presence of the student poses a danger to persons or property, or if the continued presence of the student materially and substantially disrupts the order of the school. If this standard is met, you may move on to step 4 prior to conducting a hearing. However, note that if you do remove the student prior to conducting the disciplinary hearing, the Massachusetts Student Discipline Regulations still require you to conduct the hearing within 2 days of removing the student. It does not rid you of the requirement to conduct the hearing altogether. And then, the fourth step in all disciplinary situations is to conduct a manifestation determination review. However, if an exception applies, you might be able to remove the student without conducting the manifestation determination review. As we explained, the exceptions differ based on whether the student is entitled to the protections of Section 504 or IDEA. So if the student is protected by IDEA, you may remove the student without conducting a manifestation determination to a 45-day interim alternative educational setting if the student does any of the following while at school, on school premises, or at a school function. If he or she carries or possesses a weapon, if he or she possesses or uses illegal drugs, if he or she solicits the sale of a controlled substance, or if he or she inflicts serious bodily injury on another person. Another exception, you might request an expedited due process hearing in which, at the BSEA, in which a hearing officer could order the 45-day interim alternative educational setting if that hearing officer determines that maintaining the child's current placement in school is substantially likely to result in injury. Remember, however, that this option might still not be quick enough because this process can take up to 30 days. Alternatively, if the student is protected by 504, you are not required to conduct a manifestation determination review if the student's behavior involved the illegal use of drugs or alcohol. And as Elka explained, the standard here is current use rather than simple possession. If this is the case, you find the student currently using drugs or alcohol, you may follow your regular disciplinary procedures. In all other situations involving students protected by 504, there is no way to avoid conducting a manifestation determination review. However, if you determine that the student poses a direct threat to others, you may remove the student regardless of the outcome of the MDR.
All right, another question that we received in advance of the webinar from a participant was to review how to communicate with parents who want a more rigid disciplinary action taken against a child. So we've seen this situation come up relatively frequently. One scenario is one in which two children fight. The school determines that one child should be suspended for 2 days, while the other child should be suspended for 5 days based on the school's determination of relative culpability. The parent of the child suspended for the longer period then complains to the school, asking the other child to be suspended for an equally long period. Another situation in which this scenario might arise is when the parent of a child who was the victim of an incident demands that the child who committed the offense be very strictly disciplined. In all cases, it's important to remember that the Massachusetts Student Records Regulations and the Federal Family and Educational Rights and Privacy Act, or FERPA, prohibit a school from sharing student record information about one child with anyone else unless an exception applies. Student record information includes information regarding behavioral incidents, such as investigation results, and information about discipline that was or was not imposed. If a record is created that contains the names of multiple children, the record becomes part of each named child's student record, and each of the child's parents would have the right to review that record. However, in that situation, the names of the other children should be redacted. Therefore, in these situations, it's best practice to simply and clearly tell the parents that they are not entitled to any information about any children other than their own, but assure them that all actions were taken to ensure the safety of their own child and the best interests of their child.
We received another question in advance asking us what type of documentation is necessary on an IEP or Section 504 plan with regard to bullying concerns. We'll start off by pointing out that the Massachusetts Special Education Regulations require all initial evaluations to include, among other things, an assessment of the student's social relations with group, peers, and adults. Similarly, IDEA requires that the initial evaluation include an assessment regarding the student's social and emotional status. The Massachusetts Department of Elementary and Secondary Education, or DESE, has interpreted this to mean that IEPs and Section 504 plans should include consideration of the supports that the child needs to build that child's social skills and proficiencies to avoid and respond to bullying, harassment, or teasing. Therefore, at the very least, you should make sure that the documentation for initial evaluations indicates that these considerations were addressed. Also, IEPs and 504 plans should include skills and proficiencies that the child needs in order to avoid or respond to bullying, harassment, or teasing. While we will not get into the details now, DESE has put out a technical advisory listing several such skills and proficiencies that a school district may incorporate into IEPs or Section 504 plans. Moreover, the Massachusetts bullying laws require schools to provide age-appropriate instruction in each grade that is incorporated into the school's curriculum. IEP and 504 teams must make sure that students with disabilities are put in a position where they're able to make progress toward this curriculum. So the IEPs and 504 plans must also include documentation to that effect. And finally, DESE has also advised that each time an IEP or Section 504 team convenes, the team must consider whether the student has been involved in any bullying incidents. So the records of team meetings should document that these considerations were addressed. We got one more in advance.
Yeah, there was one more question we received in advance. A family wishes to have written into the IEP that their child cannot be suspended. Well, I never wish to suspend. This is not how I have ever interpreted the law. Can you please provide clarification on this? So I agree with the person who posed the question. While I understand why a family might wish to have written in the IEP that their child should never be suspended, this doesn't seem to be an appropriate use of the IEP, or that the school is required to in any way limit the tools that they might have to assist children in their development and education. All right.
Looks like we also got several questions throughout the course of the webinar, and we have some time to address each of them.
Or at least some of them.
At least some of them.
All right, so I'm going to read the first question. What if the parent has expressed a concern, an evaluation has taken place, and no disabilities were identified? Is this child still considered a student with a disability? So, Allison, you want to take a shot at that?
Sure. So if we look back at the rules that we addressed earlier, so we'll first start with IDEA. A student is considered a student with a disability if one of those three things that we discussed happened. One, if the parent provided a written concern to the school that his or her child needed services. Two, if the parent requested an evaluation. Or three, if the parent expressed, if a teacher or another staff member expressed concern about that behavior, about that student's behavior. So here it looks like they're considering a situation where the parent expressed a concern, the school conducted an evaluation, and that no disabilities were identified from that evaluation. If it happened in that order, if the parent first expressed the concern, and then in response, the school conducted an evaluation, and the evaluation resulted in a finding of no disabilities, I would say that the student is not a student with a disability. Elka, do you agree?
I do, but one thing to keep in mind is that the parent might appeal that, right? That's one situation in which parents do have the right to challenge the school's decision. But for the moment, I would say that is not a child with a disability. All right.
Got another question. Can the manifestation determination review take place prior to the disciplinary hearing? Right. You want me to take this one?
So this is something that we looked at one point.
Right.
Do you remember?
I do. I think the answer here is no.
Right.
Because you only have to conduct a manifestation determination review if the suspension it will be a change in placement if it's implemented, if it would constitute a change in placement. You don't know prior to the hearing whether you actually intend or if there is a factual merit to imposing the suspension. So you first have to conduct the hearing to decide that, to decide how long the hearing the suspension might be, and then from the results of those hearings, you have to determine whether it is a change in placement, and only then are you required to conduct the MDR. Right,
and this is a situation that has come up. Now, one nuance here is the situation in which it arose. I don't know if you remember. I think it was two that we were looking at simultaneously. In one case, the reason why the MDR had been conducted was there actually was a hearing. Mm-hmm. There had been a hearing, and I don't remember what happened with the discipline, but the behavior was substantially similar with the next hearing, So it was effectively considered a single MDR. Mm-hmm. A single hearing, and the MDR really traced back to the first hearing. The reason I mention that is I'm sort of curious that the MDR has taken place before the hearing.
Right.
And I assume that something happened to trigger the MDR first. I guess the other thing to keep in mind is that the same people who are meeting for the MDR might be the same people who would need to meet in order to determine what services need to be provided to the child during suspension. So as a practical matter, you really have to hold it after the hearing. All right, next question. What types of alternatives to discipline are permitted? For example, helping repair the wall you broke or staying after school for detention. So that's very interesting, the helping repair the wall, and I'd want to think about that because there are some questions that might arise as, in terms of insurance and child safety. So I don't know if that's strictly a special education disciplinary question, but staying after school is something that has come up from time to time, and that's normally fine, but you really do need to look at the child's IEP and Section 504 plan and confirm that it's consistent with that plan. So for example, if the child's IEP plan requires that child to take the bus home because that child is not able to negotiate private transportation, making the child stay after school and miss the bus would be problematic.
Sorry, we're trying to scroll down to the next question. Okay. We have a bunch here. All right, the next one asks what we would advise districts to do if a parent refuses to attend a manifestation determination meeting. So as Elka explained earlier, you have to make extreme efforts to obtain parent participation, and that could involve doing it via video conference, via telephone, and you have to document all of those efforts. If the parent refuses to attend a manifestation determination meeting, and Elka, jump in if you think I'm misstating anything, I think what you would do there is let them know when and where it is, and again, document that you've done that, and hold it so that if they choose to attend, they know when and where it happened, and they cannot thereafter claim that you conducted it without giving them the opportunity to participate.
Yeah, that's right. We haven't found a reason to believe that you need to go through an expedited due process hearing at this point, unlike a situation where the parent might be refusing an evaluation. It's a little different. All right, let's see if I can scroll. I'm not very good at this. Okay.
All right, the next question, all right. For any student or parent, not just the student with a disability, what do you advise districts to do when a parent refuses to accept a suspension and sends their child to school anyway?
Oh, that's really interesting. I have not had that situation. I think that might be a good time to engage the school resource officer, or if it's a disruption, think about court relief. I mean, you really have to weigh the pros and cons here, but that's something that might be available to you.
All right.
Okay, so I'm getting the signal that it's, oh, we have time, I guess, for, okay. We got a slight revision of the prior question. Is an alternative to discipline, can you make the child clean up the mess instead of repair the broken wall? And the answer is yes. That's pretty straightforward. You know, again, always consistent with the child's limitations as expressed in the 504 plan or section or the IEP, but yeah, that should be fine.
Especially if you're having the student do that during school hours and not after school, you want to make sure that the student is not missing critical services.
Yeah. So this concludes our presentation. We hope you have found the information helpful. A copy of the presentation with the recording will be sent to you as soon as it is available. Again, we have provided our contact information if you find you need additional legal assistance on this subject and other important related topics. I think we actually covered most of the questions today, but we will try to produce a Q&A that just lists the questions and provides possibly more coherent responses than we were able to do on the fly. This and other webinars were produced by our law firm and are available on our website, www.kb-law.com. And thank you all for joining us today, and have a great rest of the day. Take care.